Hello everyone. Today we're going to talk about some of the changes with CFPB from a realtor's perspective. So let's get started. How's everybody doing?
Very good.
Great.
So I understand the lender is responsible for compliance. How does this really impact the realtor?
Well, Bill, that's a great question. There are big changes under TRID. The lender is responsible. This regulation is promulgated under Truth in Lending. There's significant liability for the lender under Truth in Lending. But there's also the Dodd-Frank Act, and we can all share liability under Dodd-Frank for violations of federal consumer protection law. So the CFPB has got broad authority under Dodd-Frank to institute examinations and actions against banks, non-banks, and related persons, which can include title companies and realtors. The Bureau also has broad authority to impose penalties on us all, up to $1 million per day per violation for a knowing violation of federal consumer protection law. So that could include TRID, it could include RESPA, it could include Graham-Leach-Bliley, any of the federal consumer protection law. So big changes, important to understand the new rule, the new forms, and the new timing requirements.
So CFPB could come after a realtor for violations of TRID or other federal consumer protection laws?
Yes, Bill, it has happened. So the Bureau does have broad authority to conduct examinations to detect and assess risk to consumers and compliance with the requirements of any federal consumer financial law under Dodd-Frank. A well-respected real estate company in the Northeast is currently defending an enforcement action and a class action lawsuit. So it's important to remain in close contact with the title company and your clients throughout the transaction process to ensure that you understand how the process is proceeding and to ensure that you're aware and can communicate that with your clients.
Well, Bob, what about moving the closing date?
That's a good question, Bill. We've discussed this, and when we look at the timings and the process that you have to consider, the additional time that's allowed, we really need to make sure that the communication is key, that everyone is communicating about the current date. If it needs to change, that needs to be shared as soon as possible. Any type of changes that are before or after the initial closing disclosure require collaboration with the lender, which is additional work. So settlement agents need to allow for time to do that, as well as lenders need to be able to assist us in getting the final figures fit to the consumer.
Will I still be able to place my real estate transaction with my favorite title company?
Generally, yes, except the lender may require that you choose a title company that is on their approved list. The consumer is to use a settlement agent that is approved by the lender in order to make sure that the lender is confident and is able to get the support from the settlement agent that's necessary to comply with the rules.
Can the realtor get a copy of the CD mailed to them by the lender at the same time the consumer is mailed one?
You know, typically we don't know that that's going to happen. The lender is required to provide the closing disclosure or the CD to the consumer. The rule does not require delivery of the CD to the realtor, and it's unlikely that the realtor will receive an advance copy of the CD before it is delivered to the buyer or the consumer. So the lender will send the CD to the title company when it is sent to the buyer or consumer, but this may vary, and your client can always share a copy with their realtor though.
Will title agents be able to give the realtor a copy of the CD?
You know, because of privacy, we are not comfortable with that. There's clear laws in the Graham-Leach-Bliley for protection of the consumer's personal information. So we would really rely on the buyer to provide that with written authorization that could be shared with the buyer depending on what's provided to us as a settlement agent.
Will title agents be able to give the realtor a copy of the seller's CD?
And again, I'm going to say because of privacy issues, we would look at the seller either releasing that information or have proper authorization from the seller to do so.
So it sounds like the lender will have more control of the closing. Will the realtor still get to be at the closing table?
Yes, we expect to see that process to not change at all. Again, the main key is that we are communicating about the scheduling of the closing. We want to make sure that the lender is not only prepared but able to comply with the new guidelines and the timeframes that are established for the new rules and the new closing disclosure.
So, how will the rule impact and change the closing process?
Well, the rule may affect the contract term that you help negotiate. So, for instance, a 20-day closeout may no longer be realistic. If your contract term sets a number of days to close, probably adding an additional 15 to 20 days to the contract may be safe, just to be on the safe side. If you use a contract form that requires you to fill in a specific date, you'll need to communicate with the lender and closing agent to determine a realistic time frame for closing under the new rules. Same-day closings may be risky per some lenders. Some say it's okay, some say it's risky, so don't really try it. So that means back-to-back closings, probably a time to be careful.
How do I plan for transactions times to be lengthened in the real estate contract? And what if my contract does not fit the timeline?
Be sure that all contract amendments, whether they're changing figures, dates, names, anything else, those types of things, are communicated to the title company and lender as soon as they are signed.
What are the things I can do to help my closings go smoothly?
You know, Bill, to avoid a delay in your closing, it'll be important that you have everything ready for the closing, no less than 15 days prior to closing. The title company or settlement agent will have to provide all transaction details to the lender at least 10 to 14 days prior to the closing. Things to consider would be disbursement authorizations, home warranty invoices, any other type of invoice that may be related to the transaction that's not driven by the lender, amendments, as Marvin said, figures, anything that's going to change those numbers or affect those numbers must be to us and to the lender well in advance so we can meet the timing guidelines. Also, when the law first went into effect, considering adding a cushion to the closing date was really important. In the beginning, if you're typically writing 30-day contracts, you may want to look at 45 days, unless you're confident your buyer's lender can hit the closing timelines.
How can I manage my client's expectations?
I think realtors will need to be able to explain the new forms to the buyers and the sellers, so they should become familiar with them and be able to converse with them, explaining the numbers, etc., as they're requested in today's world. Learn the time limits and do not overpromise a quick closing. You need to, as Marvin said again, manage the clients, manage the expectations of the clients by letting them know that any changes may require additional disclosures, a review period which may also require delays due to the closing.
Any final recommendations?
I would basically say communicate, communicate, communicate. I know the real estate community has relied heavily on location, location, location. I have to say that we look at communication more so now than ever. We heard that in 2010 with the HUD, and now I would say that you really should focus on that, especially at the onset of the rule. We need to adjust and become comfortable with this new process.
Well, very nice. Thank you all for that great information, and we're ready to communicate, 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 and change, change, change.